Want to pass your real estate exam? Well, let's do some questions for national and Texas state at the end, and also the answers. So prepare yourself to participate. Type the question number and the letter answer in between all the questions. I review the questions, explain them, and also the answers to help you best prepare for your exams, whether be it a national exam or your Texas state. And of course, as always, vocabulary, and more vocabulary, right? Practice lots and lots of questions. Review the topics that you're weak on, but not the whole books, all right? From the questions, you can determine what areas you're weak on, or if you've taken the exam before, you'll determine what section you also need to study. So we're continuing from... when was it? Saturday. And so I follow sometimes in series and hold on here. I'm a little lost. Not really lost, okay? Just need to make sure I've got all the questions correct here. And also the answers to make sure I have extra explanation or answers for you. And when in doubt, hey, Google it. Okay, that's what I do a lot of. I Google answers, I Google vocabulary, questions, and Google just responded to me, on my phone, say, hey, Google. And Google, there you go, and Google responds. All right. So this is Lillie Handy Dominguez, or Wild Lillie Handy, coming to you from San Antonio, Texas with YouTube Agent Prep. Should this be your first time to my channel, remember to tap that subscribe button, click that little bell so you're the first to get notified every time I go live, and like this video if you found it useful. So let's get ready for questions and answers for national, which applies to all 50 states. And anybody watching the replay, the class is designed to allow students to participate during the session. So, hey, if it's too slow for you, just speed forward. Change the pace, okay, the time to play back to 1.5, 1.75, 1.2, as long as you keep understanding the questions or what we're reviewing. And if for some reason your resolution is not correct, if it's really blurry on your own video, you have a gear on the bottom, and it's usually like on the middle of the bottom to the right. Click the gear and then select resolution and put it to 720 or 1080. And that way you will get a clear picture. All right. So number 147, these are national questions. Under what condition can two individuals own a property as tenants by the entirety? Remember, that's one of the 4 different types of ownership. So tenants by the entirety. A, if they so elect at the time of acquiring title. B, if they are blood relatives. C, if they are married. Or D, if they incorporate. So type your answer in the chat. So tenants by the entirety. I will tell you this, it's for 2 individuals. So type your answer in the chat. Anyone? Nothing yet? Nobody wants to take a risk today. So tenants by the entirety is for a couple that is married, right? And so it's for husband and wife. Therefore, the letter answer is C. Hi, Johnny. Thanks for joining us. Oh, very good, Johnny. So 1.47 C. And what are the others? So hold on here. I'm trying to type the answers on Facebook. What are the other types of ownership? Can anybody type at least one? So we know tenants by the entirety is one of them. Then there's one of them that is called for an individual or an entity. That is severalty, right? You sever from everyone else. It's just for one individual, an entity like an LLC, a corporation, or a partnership. And only one person gets to sign. Well, that's not working. Is anybody watching on Facebook? I'm trying to type the answer in there, and maybe my Facebook is really slow. So that was the answer right there, okay? So we've got severalty, tenants in common, 2 or more, no survivorship, and it goes to their heirs or whoever else they leave it to. Then joint tenancy has to meet 4 conditions, TTIP, time, title, interest, possession, 2 or more, and it does have survivorship, meaning if one of the partners dies, it goes to the other. And 4, tenants by entirety for couples. In Texas, it's community property. And I think there's about 8 other states that use community property. So the majority use tenants by the entirety. Very good. Right, number 48. When an estate is held in a trust, which party holds legal title? A, the beneficiary, B, the trustor, C, the trustee, or D, the grantor. Who holds legal title? Okay, they actually are holding on to the title. Hi, Lisbeth. Thanks for joining us. You're on YouTube today. Awesome. You must be at home. So whenever there is a trust, there's 3 parties involved. So who holds the legal title? No one? Okay, the answer here is the trustee. So the beneficiary is the lender. Okay, the trustor is the borrower, the new owner. The grantor is the one that sold it. Okay, and so when there's a trust, okay, as in a deed of trust, there's a trustor, a trustee, and a beneficiary. The beneficiary is the owner. So in a mortgage, that is the lender. And they entrust the trustee to hold on to the legal title and follow the instructions in case there is a foreclosure. And the trustor is the current owner. And the current owner could be an individual, or it could be an LLC, a partnership, or a corporation. Okay. And it can be named after sometimes a name of the property. So it depends what kind of a trust here. If it had said deed of trust, it would have been a lender. If it's a land trust, it's a trust that is used for multiple asset protection. But anytime there is a trust, okay, there is a trustee. So the answer here is trustee. Yes, so severalty was one of the other types of ownership. So in an estate, okay, because it's an estate, right? Interest in real property. That's an estate. So they put them in a trust. So they're the grantor or the trustor, okay, are the owner. And the grantor transfers legal title, okay, to a fiduciary who will be the trustee. And they hold the title and manage the estate for the benefit of the beneficiary. The trust may be created by a deed, a will, or a trust agreement. So usually we use the trustor instead of the grantor, but the grantor and the trustor are the same. It depends on, whether it's a will, a deed, or a trust agreement. So if you missed this one, go back and review beneficiary, trustor, trustee, grantor. And when there is an estate, meaning you have an interest in real property, and what is it, who holds it, the legal title when it's a trust. Okay, something's not right here. Okay, I'm typing the answers in the wrong place. On Facebook, that is. All right, number 49. Because keep in mind, I'm streaming to two different locations. So I'm using StreamYard. That's a software that allows us to stream to multiple places like YouTube, Facebook, LinkedIn, or other social media. So if I want the answers to show up on Facebook, I've got to type them there. Because of course, I have the private group, which many of you are members of, and you have access to other resources on the private group under the different guides. I believe I have 14 different guides on there. And one of them, I would recommend that you go in there and it's print the night before the real estate exam, cheat sheet before the night before the real estate exam. It's helped quite a few of the other students using that the night before the actual exam. So 148C was the answer. Number 49, Tanya buys a 4-bedroom condominium. That's a large condominium. As the new owner, she has the right to do what? A, sell or mortgage the unit without impediment from individual owners of neighboring units. B, sell the interest in the physical unit separately from the interest in the common elements. C, prevent non-owners from using the unit's owner's portion of the common elements. Or D, exclusively possess and use those portions of the common area structurally or functionally necessary for the operation of the unit. So if you're buying a condominium in a condominium subdivision, gated, what is a condominium? Where do you find condominiums? Does it have yard that go with it or not? Do you use the inside space? Do you use all of it? Do you have rights to everything? Can you encumber it all or not? So questions that should go through your mind. So a 4-bedroom condo she bought. Which right does she have? To sell and mortgage a unit without others interfering? B, to sell the interest in the physical unit separately from the interest in the common element. That means the outside, the yard, the party house, or facilities. C, prevent non-owners from using the unit owner's portion of the common elements. Or D, exclusively possess and use those portions of the common area structurally or functionally necessary for the operation of the unit. Hi, Ms. Elias Quintanilla. Thank you for joining us. The answer is not D. So remember, a condominium, you own the inside space of the condominium and you share the common areas and pay a monthly due for the common areas to be maintained. Could be gated community, for repainting or power washing the outside, for replacing the roof, maintaining the pools, doing the maintenance to the gardening. So the answer is A, sell or mortgage the unit. Okay, they own the unit, all that airspace in that building without impediment from individual owners of neighboring units. So we don't own, we own a percent of the land, but that's with the homeowner association. Right, the homeowner association owns the whole land and we pay monthly dues to maintain that land and we have to follow rules and procedures and restrictions. And I say we because I currently live in a condominium subdivision. And I'm really enjoying it. I didn't think I would, but I am. I've always owned a home, except when I was in college, I rent it. And then when I moved to San Antonio, I ended up renting an apartment for 2 years, and I really enjoyed it. So then I started looking at condominiums. And the condominium due is not that high. It covers typically water, sewer, and trash. And of course, the outside maintenance, the insurance that the condominium facility, the homeowner association manages, because those are volunteer officers that are elected. And so insurance covers all the outside, roof has to be rear, garage doors, actual doors. Everything has to look the same from the outside. I had a Mexican blank hanging on one of my windows. When I first moved in, I didn't have shades or blinds. They came and told me, oh no, you can't have a colorful window. Okay, it's got to be neutral, a beige or white color. All right. So now y'all got it, right? D it says exclusively possess and use those portions of the common area structurally or functionally necessary for the operation of the unit. Well, they don't have to, all the common areas, they don't have to be structurally or functionally necessary to operate the unit. You could have a pool. You don't need the pool to operate the unit, right? You don't need the trees for that. Those are common areas that everyone gets to enjoy and share by paying a due. Okay, number 50. So did you all get that? That's different than a cooperative. A cooperative is when you have the owners of the proprietary, okay, they get to lease, okay, a cooperative. They're shareholders of the cooperative, so they have to lease the particular unit. All right, number 50. A condominium owner's share, okay, a condominium and owner's share of maintenance and operation expenses are based on what? A, the unit's pro rata share of floor space. So how do they determine how much each individual is going to pay for that unit? Some units are going to be, large, some medium, some small. So how do they determine that? So the unit's pro rata share of floor space. B, the unit's pro rata share of the property value as defined in the declaration. C, the number of shares the owner purchased in the condominium association, or the assessed value of the condominium unit. So every unit has a different price, okay, depending either, well, I'm not going to say a whole lot because then I'll tell you the answer. Come on, type your question number and the letter answer in the chat. Okay, so we've got 50D. It is not the assessed value. So take another attempt. Take another attempt. Try it again. The answer is B, the unit's pro rata share, okay, a prorated amount, okay, from all the condominiums that they have in there, depending on the size and the value of that unit. In the condominium where I live, it's based on the airspace, okay, the square footage of the unit. Here it says the unit's pro rata share of the property value as defined in the declaration. So some may have it a little bit different. So this could be a percentage of the total value of the condominium subdivision. And others might be just on the square footage of the particular unit. So for this question, the correct answer is a prorate declaration as part of the homeowner association documents. Okay, so we had a D. The assessed value is basically used for property taxes. That's about one of the only things that it's used for. We as a realtor, I like to look at different numbers. I will look at the assessed value. I'll look at the comparables in 3 different systems. I'm a little analytical, sometimes get into analysis paralysis. So, we can use it through the CMA, through another resource that we have called Realtor Property Resources, and the assessed value just to determine and compare with other properties that have sold. We'll see, okay, if that property, if the 3 comparables have an assessed value that's 10% below the current markets, then that's an average to take. That if the assessed value is 500,000, then 10% greater, okay, of that would be 50,000. So then I could say, all right, it could be about 550,000 based on others. However, the actual comparison has to also meet the comparable market analysis. So, hi, Michael. Thank you for joining us. Number 51. Well, let's see what the book answer says. All right. So the book, reading the wrong answer. The unit's pro rata share of the property's ownership as defined in the declaration determines the amount of units owner's assessment. So that's a different assessment than the property tax assessment that is done by the property tax assessor. For example, if a unit represents a 2% share of the property value, the unit's owner assessment will be 2% of the property's common area expenses. And in my case, it's based on the square footage. So they've determined it based on the value. And then I've noticed that every unit my size has a certain homeowner association dues, which is used for maintenance and operation expenses. So thanks for joining us, Bustin Genthi. We're doing great. Hopefully you're here to do real estate exam questions to prepare for the national and then the Texas state. Okay, number 51. By contrast to a condominium, the owner of a cooperative owns. Okay, so now we're looking at a condominium and a cooperative, 2 different types. Okay, so A, share in a corporation or association and a proprietary lease in a physical unit. B, a fee simple interest in a physical unit plus a tenancy in common elements. Or C, a tenancy in common in a physical unit and the common areas. Or D, a ground lease in the physical unit's pro rata share of land and proprietary lease in the unit. Well, hi, grandbaby Mila. She's watching it with me. Oh, hi. How you doing? Nice to have you here, grandbaby Mila. That's awesome. So we're on number 51. Yes. Okay. So contrast to a condominium, the owner of a cooperative, so they could lease it or they could own it. All right. So in a condominium, the owner of a cooperative, okay, owns B, shares, sorry, I was reading the answer for 150. So they have shares in a corporation, okay, or an association, and a proprietary lease in a physical unit. So corporations will have them and they'll use them for shareholders or employees or others to lease a particular unit, but they have shareholders. So in a cooperative, like you have a corporation, right? Corporations have shares. And so they have different shareholders that buy so many shares. And then they elect okay, board members, right? Or officers. So by contrast, a condominium, you own the airspace in a unit. In a cooperative, it's a corporation. Okay, so they own shares in a corporation or association, and they can have a proprietary lease in a physical unit. Marcela, so did Mila, hello, sending you hugs and smiles. So when you see cooperative, okay, there'll be a corporation and they lease. Oh my gosh, what the heck am I doing wrong here? Oh, she said, thank you, teacher. Just tell her I'm not a real licensed teacher, right? But I am a realtor. She could say a tutor or mentor and a tutor. But yes, she can call me a teacher. Thank you. All right, number 52. Here we go again with a cooperative. In a cooperative, real property is owned only by A, the individual unit owners, B, the individual unit owners and the cooperative association, the cooperative developer, or D, the corporate entity of the cooperative association. So remember that we have 4 different types of ownership, right? One of them is called severalty. You sever from everyone else and you're just one. And that can be an individual, that can be a LLC, that can be a partnership, or it can be a what? Corporation, a corporate entity. It's an individual or an entity. So with a LLC, it'll be a member that will sign. If it's a partnership, it'll be one of the general partners that'll sign. And it'll be a partner that'll sign. If it's a cooperation, a corporate entity, it'll be a board member, a general member. I think I got it right. It's a member, a partner, or a general member. So only one individual can sign. That's why it falls under severalty. Person to an LLC, of the LLC, a partnership, which is the sole proprietor of an LLC. And then if you have partners, partnership, you'll have a particular partner managing it. And then if it's a corporation, you'll have board members or a general member. And if I said them wrong, correct me. If you Googled it to see who's the person that signs for each of those entities. I just know it's one individual. You know, the more I do these sessions, the more in detail I understand each question and it triggers. Because a lot of times, you know, when I was doing them, you know, I'm reading them and I'm explaining on and the answer, and yet I go and research it later, or I Google it, okay, to understand it better myself. Okay. All right, very good. Did anybody answer it incorrectly? Nope, we've got D. All right, number 153. In a timeshare freehold, okay, what kind of timeshare? Freehold. Remember, it can have leasehold or it can have freehold. And there's a difference. So in a timeshare freehold, owners acquire what? A, an undivided interest in the property as tenants in common. B, a renewable periodic tenancy for a portion of a year. C, pro rata share of a leased fee. Or D, a tenancy in severalty for a portion of the year. So what is a timeshare? Now, can realtors sell timeshares? Yes. So if you go to a lot of these resorts, you'll see how they have a very aggressive team that tries to get you to buy something, and they offer you free money. They offer you tours, guides, and things like that. However, you know what? They're excellent salespeople to get you to buy, or to get us to buy. So when you buy a timeshare, if any of you have bought one at a huge resort, do you live there year round, or do you only use it a percentage of the year? Do you use it for a week, 2 weeks, a month? It depends, right? It depends how many shares you buy. It's a time share for a certain period of time that they share a freehold unit, right? So you have the keyword time, they share it, and it's freehold. Okay, they have the right to sell it, encumber it, their percentage or their share within that timeshare, and they get to enjoy, possess it, and they have a freehold type of an estate. Right? So the answer here is A. They have an undivided interest in the property as tenants in common. They own it in common with many other shareholders that get to enjoy it at a different week or month or however many weeks they have bought every year. And they still pay a maintenance fee, kind of like an HOA. So first they're purchasing the interior of it for a particular time of the year, and then there's a maintenance fee for the whole area. Almost seems like a condominium, right? They own the unit space, but not for the whole year, right? It's not their primary residence, only for a particular time of the year. And then we still have to provide money to maintain the outside. Oh, let's see here. Oh, night, Miss Bailey.
Good night.
Good night. Sleep tight. All right, so now we go on to number 54. So did everybody get that? Well, we only have one person answer. Elias. Okay, no risk takers, right? As I usually say. Jim, what's his name? Jim Cohn or Jim, Bond says, the day we were born, it is a risk. So the moment you walk out or you were born, it came out of your mom, you're dealing with risk. All right, 54. a party has just purchased a manufactured housing unit. When is this property considered real property? Okay, you have a manufactured home. So what is that? A mobile home, a modular home that is on wheels. So when does it become part of the real property? A, as soon as it is purchased. B, as soon as it is constructed. C, as soon as it is affixed to the ground. Or D, this form of property is considered personal property at all times. No, there is an exception. So remember, you have personal property that can become fixed to the land, and then you can have what do you call it? A professional fixture, a trade fixture that can be removed, right? So it's either affixed or it's removed. So personal property can be affixed and it can be removed. So based on that, what do you believe the answer is? So Miss Cindy answered C. Anyone else? Going once, going twice, gone. The answer is C. So it can be bought from a lot, like where you go buy cars. They sell manufactured homes, which now seem like really high-end homes. Some of them are really expensive. So once it's installed on a concrete foundation, or the wheels are removed and a skirt is added to it and the title is removed, okay, so they convert the title as part of they remove the title to the manufactured home. So it is not a personal property. It becomes affixed to the land, and now the land includes the manufactured home. It's all real property. So when the property is considered real property, as soon as it is affixed to the ground. And in some places you have to tie it down with cables. Well, especially when there's hurricane or tornadoes, right? They cable them down, but not all places. All right, so we started out with number 47. We could stop here or start a new section or leave encumbrances for Wednesday. We've done 8 questions on national. So do you want to have a couple more? So we do 10, or should we cut it there and then start with encumbrances, liens, title transfer, and recording and leases next time? Giving you an option. Answer in the chat quickly. All right, if I don't hear anything, I'm moving on. All right, we are going to let it be with this and start the next test on the next session. So we're going to move on to Texas state questions. I'm going to highlight that and bookmark it. Okay, now I have go to 10. Okay, I haven't gone to the next. All right. So thank you for answering. Let's do a couple more. All right. All right. So we're going to go into the test 2 of this book. Okay. And this is the book. Awesome, awesome book. Texas Real Estate License Exam Prep by Metling, Kuzik, and Hamilton. It's a small company, and so far they've published 26 states, and they're adding more states every year. And they're producing a new one for Texas. So they have, like I mentioned, 26 different states. Now the national is the same for all 50 states. Okay, that's why it's called the national exam. Okay. So encumbrances, which are what? Liens, at property. Doesn't have to be financial. It could be an easement. All right. Then there and other types of judgments. Then there's liens. It can be a mortgage, a home equity line of credit, commercial line of credit, mechanical liens. Okay, that type of thing. Child support liens. Then title transfer. Okay, transferring the title using a warranty deed, recording the warranty deed and the deed of trust, which is the mortgage in other states, and leases. Number 2.1. All right. Hi, LaQuinn. Just in time for Texas. Oh, no. I'm sorry. I'm doing a couple more national. All right. Which of the following describes an encumbrance? If you don't remember, then go back to study vocabulary on encumbrance. So a third party's right to encroach upon a property without the permission of the property owner. B, a third party's right to claim the sale or proceeds of a property that has been mortgaged as collateral for a loan. C, can't see that all. C, a third party's interest in real property that limits the interest of the freehold property owner. Oh, do. Come on. Jeez. I swear. Okay, it's going to be kind of small here. Yeah, I don't like this. I'm not getting anywhere here. Wow, that seems really small. So I can't seem to hit the right point. All right, so it's going to have to look small. Okay, so what best describes an encumbrance? All right, so far we have C. Anyone else? And yes, the answer is C. A third party's interest in real property that limits the interest of the freehold property owner. That's an encumbrance. There's a cloud on title. So it limits the freehold interest, okay, of a property owner. So it's a third party's interest. Could be a lien holder, mechanic's lien, some other judgment. That's an encumbrance. It's attached to the property as a lien. So it's a cloud on the title. It could be just also a name, okay, that's impacting the title, a name change. So that's created a cloud on the title. All right, number 2. Which of the following is true of easements in general? Okay, so A, they involve the property that contains, let me see if I can get that one bigger. All right, so which of the following is true of easements in general? So A, contains the easement and a non-owning party. B, they apply to a whole property, not to any specific portion of the property. C, they only involve the legal owner of the property. Or D, they may require a specific use but not prohibit one. So easement in general. So it's like, what are they talking about? In general, what are easements on a property? Okay, no answers. All right, here comes one. A is so far. Anyone else? So remember, when you have an easement, you have a dominant party and a servient party, right? Yes, the answer is A. They involve the property that contains the easement and a non-owning party. So the property that owns the easement is the servient, right? They serve the other one. They have to provide the easement to the non-owning party, especially when it's recorded and it goes with the land. If it's not recorded, it could die with the owner or the person that the easement was granted to. So that's like easement in gross. All right, we'll do a couple more. Number 3, or we'll go to 2.5. Mr. King. Oh, hey, today is Martin Luther King. How appropriate. Mr. King wants to offer 100 acres of his property for sale. Since the property is landlocked, what does landlocked mean? Somehow the land is locked, so there's no access. He will have to put in a driveway to the road that will run across his remaining property. What kind of easement will he have to grant? A, an easement in gross, B, a commercial easement, C, a personal easement, or D, an easement appurtenant. And what is appurtenant? What is personal easement? What is commercial easement? What is easement in gross? No, it is not C. This type of easement, when they're going to put a driveway to the road that will run across his main property, his remaining property, becomes a permanent easement when it's recorded, in order so that the land that is locked either behind them or to the right or to the left or in front, depending where it's locked, but there's no access to that property because it's locked by the main acreage. So somebody owned, hundreds and hundreds of acres, and then they started to sell portions of it. Well, there was only one road to begin with. So how is everybody else going to access the land that they just purchased from this owner that had thousands of acres or hundreds of acres? They have to install an access to that land, and it becomes a permanent easement that goes with the land. So the answer here is D, an easement appurtenant. An appurtenant is attached to the property and goes with the property, moves with the land. Like a personal property, okay, like chattel, cattle, it moves, it's personal. This is permanent. It's real estate. It's affixed. It's attached. It's part of the land. It goes with the land whenever it is sold. If for some reason that easement is not recorded, then there's going to be issues, okay? Or I said there are going to be issues. More than likely, it's going to be, okay, the county gets involved and the owner, the owner wants to liquidate some of their property and get some money. So they're going to sell portions of their acreage and make sure they provide access. And they provide access for as long as those parcels are there. All right, number 24. Not 24, 2.4. Okay, if property alpha, property A, has a court-ordered easement across property B, beta, in order for alpha to have access to a public road, the easement is an what? A, an easement by prescription, B, a personal easement, C, easement by necessity, or easement in gross. Okay, so it's a court-ordered easement across somebody else's property, which is alpha, to have access. So the court ordered it, okay, because maybe that property owner A is fighting the issue and they don't want to give an easement. However, they did something, sold a piece of land, and now they got to provide it. There's no other way to get to that piece of land. So now they got to go to court, spend money in addition to, recording an easement or building a road. Some individuals are really so happy. Yes, the answer is C. It is an easement by necessity. So it becomes an apartment, an easement appurtenant. It's attached to the property and it goes with the property. And this was ordered by the court in order so that beta could get across alpha. I'm sorry. Property alpha has a court-ordered easement across beta. So alpha is the dominant party and beta is the servient party. So alpha needs access through alpha's property, okay, to get to the public road. Now, easement and gross, okay, you'll have to go back and research all the different public utilities and or a permanent easement is given to someone. So it says an easement in gross means that the easement is owned by a business or entity. So it could be by, the utility companies. They don't own the land. They own the easement, the right to access the land to go fix the power, okay, the telephone lines, the water, the plumbing or sewer system or gas. Those are our easement in gross. And it's not because they're gross, yuck. No, it is just they have full easement. So here, what's a common full utility company easements? Okay, that's one of the what? Government powers, right? Easements, one of the government powers. There's 4 of them, right? So number 5, an encroachment. What is an encroachment? You're encroaching on somebody's space, right? And so it is A, an easement that has not been recorded or on the title of the burdened property. B, an unauthorized physical intrusion of one property into another. Hold on, let me make sure I have it all on one page. C, a right granted by a property owner to the owner of an adjoining property to build a structure that protrudes across the property boundary. Or D, a structure that does not comply with a zoning ordinance. An encroachment. If you encroach into somebody's space, what are you doing? It's like when I was a substitute teacher, okay? Oh my gosh, that was quite an interesting experience. I was going to become a math teacher and I changed my mind. Students would say, you're getting into my space, right? I'd be touching their desk, says, you're getting into my space. And the principals, and though they have rules like, okay, you got to stay 3 feet apart. I'm like, oh my gosh, man. Children have more rights than the teachers and the principals and, all that. Dang. What happened to discipline? Respect. Yes, I noticed Liz answer. So she must be having a delay with her internet. I noticed that. So Lisbeth, your answer for number 4 is actually C, easement by necessity. Okay, you said easement by prescription. No, easement by necessity. And on number 5, it is, okay, when you're encroaching on somebody's space, you're abusing their space, right? You're interfering with their space. So it is an unauthorized physical intrusion. You're intruding with their space, okay? An unauthorized physical intrusion on one property into another, of one property into another. So it could be a shed, it could be a fence, it could be a little bridge over the creek, or anything like that that crosses the boundary of the land, right? Because they have an adjoining boundary, right? They have the same boundary that separates them. And how do you overcome something like this? Get a survey. if one doesn't already exist. Because I tell you what, it can create battle between neighbors. Oh man. Oh woman. And it can go, especially if they've owned this piece of land for years and years and years, and the neighbor didn't care, right? And no issues. They were really good neighbors. The fence was over, all big deal, right? But then no owners, and they want what they're. The other one said, hey, well, it's always been there, and hey, the owner didn't have an issue. Sorry, legally, okay, the boundary is here, and that land belongs to me. Get your fence out of here. Get your building out of here. So it has to be proven with a survey. So the answer is B, an unauthorized physical intrusion of one property into another. So you all get that by the different examples that I gave? So should you own a piece of land and the fence line is not right on the line? And that kind of happened to me in South Texas, okay? My neighbor was parking on my concrete, right? I own a lot of concrete on my driveway. And we eventually decided to give him permission to park one car on the driveway because I'm not there to kind of give, awareness that maybe somebody is there. Well, they started parking two cars and then their basketball hoop. And then they started repairing their cars on my lot. So my brother says, hey, my sister's coming over for a couple of weeks. Please do not park any cars there or only one. She's going to be moving trailers in and out of there. Well, no. Did they follow the instructions? No. So I had to have a talk with them. And the owner didn't like it that I asked him to move his two vehicles. I said, you can park one, but hey, please don't abuse my neighborly. He said, well, I'm being neighborly. And I unfortunately was pointing my finger, bad habit. And he got pissed off. He said, look, your fence is onto my land. I said, actually, you know what? My fence is not on the boundary. And that palm tree that the fence is leaning on, it splits our land. So half of the palm tree is yours, half of the palm tree is mine. So my fence is leaning on my side of the palm tree. Oh, okay. But he doesn't violate my driveway anymore. So anyway, I fixed the fence. I pulled it back. So that's how quick issues can become. All right. And then you have to prove it with a survey. So anyway, that's a little story, and I'm sticking to it, man. I learned the bad way. Don't point fingers. I have a bad habit. Is I'm talking and I go like this. I talk with my hands, and I point, and he was very offended. So what did he focus on? The pointing of the finger instead of on the issue. So anyway. The longer parks on my huge driveway that, like 6-8 cars can park on. My driveway is bigger than my house. All right, so that is 2.5. We're going to go next into Texas questions. So, Lisbeth, you answered on number 4, easement by prescription. So easement by prescription is when an owner allows an individual to use their property for a certain period of time without permission in a way in which the owner should be, oh, wait a minute. Easement and prescription could lead up to adverse possession. Okay. So it's a property right acquired when a person ends up using that property, trespassing that property, and they maintain it and the owner doesn't say anything, then they can go to court and take over that piece of property. So if you ever know anybody that's, squatting on your land, if you have acreage out in the country or something, and you see them there and you say, you know what, it's just temporary. It's okay. They're not bothering anybody, but they end up staying there for years and years and years. They can take it away from you through easement by prescription. Oh, yeah. There's different ways to get property, and some of them learn the loopholes that are allowed by our government and put in place, especially for taxes, okay? Tax write-offs and things like that. All right, so any questions on the national? We'll go to Texas state questions. And you're welcome to stay for the Texas state. It's not in particular to your state. However, you learn on keywords and other things like that that I point out and explain, so that when you're studying your questions, you can pay attention. You're going to have similar words, right? Vocabulary in real estate is vocabulary. Some states have more vocabulary, especially when it applies to their particular state. So some vocabulary can be different. Okay, we are today on, excuse me, we're starting out with 13.6. So no questions, right? All right, so we're starting with question point 13.6 on page 207 in the book, and the answers are on page 284. So let me do this and share the screen. Five, so we start on number 6. So change your thinking cap to Texas state. All right, number 6. Okay, let me type on here for anybody watching the replay. Texas state questions. Start with Texas state first and then the other, because usually the majority of the people that attend are national. And that way, you know, they can come in, leave, and then the Texas people can stay and watch Texas state questions or come in. And those of you who have been following me now know that I do it at the second half of the class, or the third or the last third of the class. So for anybody who's been to my channel, this is your first time, hey, tap that subscribe button, click that little bell so you're the first to get notified every time I go live or I upload a short or other type of video. And like this video if you find it useful. So if you're watching on YouTube, hey, send me some love and tap that thumbs up and let me know that you like it. If you don't, hey, that's all right. No thumbs down, okay? You have a choice to watch or not to watch. Number 6, a sales agent is interested in selling a duplex. Okay, what's a duplex? You have 2 units, right? Connected. He owns that is not, a sales agent is interested in selling a duplex he owns that is not making enough money. In fact, the units are in the red, what it means negative cash flow, right? They owe money with no end in sight. So it can be a money pit. Which of the following is true? A, the licensee is barred from personally selling the property since he is licensed, he or she is licensed. B, the sales agent may sell the property provided they disclose the loss in a pro forma profit projection. Or D or C, the licensee may sell the property without restriction regardless of their profitability. Or D, the sales agent may sell the property provided they make proper disclosure as to their license status. No, it is not B. There's something more important than disclosing the pro forma data. That's on the financial aspect of it. But what is more important when we're selling our own property and we are licensed? Starts with the D. Yeah, D. Disclosure. The sales agent may sell the property provided they make proper disclosures as to the license status, right? Because we're not the average person selling a property. We've gone through school, we've gone through exams, we've gone through training, legal classes. You know, we have more education than the average person trying to sell properties, unless they're investors and they buy and sell regularly. So the answer is D. So let's see, there was an answer B. B says the sales agent may sell the property provided they disclose a loss in a pro forma. No, that comes down to the financial purposes. Before that, has to disclose I'm a realtor. I'm a Texas licensed realtor, or a realtor licensed in Texas, in Georgia, and in New York, in Florida, California, wherever, Michigan, Wisconsin, you know, one of those 50 states. Hi, Indy. Oh my goodness. I had a dog, a wolf dog that I love named Indy. Actually, her name was India when I lived in Oregon. And then in Indiana, there was the Indianapolis 500, the Indy 500, right? Which I never went to. Bummer. Then. All right. 3 of the following statements constitute a violation of acceptable brokerage practice, and 1 statement represents acceptable practice. Which one is not a violation? Okay. So which one is a good statement, is good practice, not a violation of acceptable brokerage practices? A sales agent tells a buyer that the seller can paint the house in 2 days, a job that takes 4 days. B, a sales agent places the new sign on the property advertising a reduced price despite the fact that the listing expires in less than a week. Or C, a broker uses $500 from their trust fund to pay a personal fee and redeposits the money back into the account within 24 hours. D, a sales agent tells the buyer that they guarantee, they got a crystal ball, right? The property will appreciate as it has for the last 10 years. Do we have a crystal ball, right? Can we commingle, right? Can we mislead? So those are little key words, and each of the questions, even though they don't exist in the question or the answer. So which one is not? Be careful when you see not. So they're saying there are 3 violations. So you think, okay, so which one is not true? So which one is not a violation? Which one is a good answer that doesn't violate the law? These types of questions have caught me, okay? And I've selected the wrong one. So which one is acceptable? It is not D. So take another attempt. You cannot guarantee, okay? That's a violation of law. That one is a violation. It's not a violation, okay? So that's one of the bad ones. 3 of them are violations. 1 of them is not. So the answer is B. A sales agent places a new sign of a property advertising, hey, this property is reduced, man. We just reduced the price, even though it's going to expire in a week. Why? Well, we want to trigger an offer, right? Even until the expiration day. Why? Because the listing can always be extended if we get it on, 1 day or the actual day and it's accepted, then the seller is going to want to extend it, and we extend the listing with an amendment. So that's acceptable. The others are not. The other says you can't say it's going to take 2 days when it'll actually take 4 days. Okay. And you can't take $500 from a trust fund, which is used for clients. That's commingling. And you can't guarantee anything in this business of real estate. There are no guarantees. There is no absolute. Now, there is absolute when it's referring to laws and requirements and policies. Some have exceptions, but for those types of things, there will be some absolutes. So you have to read the question carefully. You know, what are they? And I think the person that chose the wrong answer is and they thought which one is a violation, and they're all three a violation. One of them is not. All right, number 8. Which of the following statements would subject a licensee license to suspension or revocation? So what action would we take that would put us in line to be suspended or revoked by Texas Real Estate Commission? A, including the broker's business identification as an advertisement. B, receiving a 10% commission on a property sale when the going rate is 6%. C, placing an excess number of signs on a property for sale. Or D, persuading the representing seller to hold off on selling until the listing period expires or ends, at which time the sales agent can get a much higher or much better price. What is our job? We have to be a fiduciary to our client. That is primary. So which one would subject us to a revocation or a suspension? It's not B. So we have 2 B's and 2 D's. So I'm letting you know it's not B. So which other one could it be? If someone can get a seller to pay 10% commission, oh my gosh, awesome. That means they're showing their worth of what they're going to do for that client, and the client is willing to pay that. Sometimes they take part of that commission and they provide certain other services, okay, like power washing the house or the driveway, or they even also charge for that. There are some individual, a few far in between, that charge 10% and they succeed because they're confident about what they're going to do to their client. So that one is okay. Put in the business identification on an advertisement. Yes. Placing multiple signs on a property. That's okay. But D is not. Persuading a represented seller to hold off selling until the listing period ends. Well, if the listing period ends, you no longer have a agency relationship. Okay. So they're saying at which time the sales agent can get a much better price. Well, no. They no longer represent the client. The client is independent. So it is D. All right, let's see here. Delta, have you seen anyone gone into trouble with TREC when practicing real estate? I have. It's been a long time. And it wasn't the realtor's fault. The fact that they had, well, you know, we have to be careful. We have to keep track of communication and notes, and you can do it, you know, by saving all the emails, like the title companies, every single email they print it out. Okay. You can print everything out, because if someone gets upset and they think you misrepresented them, they can file a claim with TREC. So now it's up to TREC to determine where it's a valid complaint or not. And if they think it's valid based on what that complainant is saying, then TREC is going to request your documentation, your notes, and everything. So I have had some friends, you know, go up against that, and others that have been, at least one that has been fined $10,000 for calling the individuals on the do not call list. Okay. So the person that I recall, they're protected by the error and omissions, and they were in the right. The client was incorrect. Okay. The client was wrong. So the client lost. Thank God, to me, I never had any issues. Okay. I've had a tenant complain to track to my brokerage, okay, on an apartment complex that I owned because I needed access to spray, the condominium and the unit. And they were saying that I wasn't taking care of things and I was a bad landlord. Track and the board both told them, hey, we have nothing to do with that. Take it up with a local court. So you'd be amazed. So the best thing is to always do things legally. If in question, if in doubt, ask the broker. Do not risk it and take a chance because you could be wrong. So number 8 is D, right? It does happen. And NAR and National Association of Realtors and Texas Association of Realtors will post different things of realtors that have been fined or suspended. I haven't read any lately, but yes, they do exist. And it does happen. So best practice, follow the law. Don't do anything you're not supposed to. And you're going to say, well, how do I know I'm not supposed to? Ask, research it, call. Okay. Call TREC, call NAR, call Texas Association of Realtors, talk to your broker, not just another licensee, because that other licensee may also not be aware. So brokers are held to higher standards, have more education, and they have other training and have done many other transactions. All right, number 9. 3 of the following are license law violations. Okay, 3 are violations and 1 is not. Which one is not a violation? Okay, again, which one is not a violation? It's good practice. A licensee forgets to mail a copy of a signed transaction document to a principal. B, a broker distributes trust funds during a closing. C, a broker makes 1 monthly deposit into the trust fund on the first business day of every month. Or D, informs a prospective buyer that a property might still be for sale even though the sale has closed. Okay, so 3 of them are violations. 1 of them is not. Which one is the correct one that is legal? Type your answer in the chat. Okay, so, first one said licensee forgets to mail a copy of the signed transaction. What are we required to do when we have a contract? Broker distributes trust funds during closing day. Is that when trust funds are distributed? C, broker makes 1 monthly deposit on the first business day. When are we supposed to deposit money that we receive from clients? Should we have our own trust account? D, informs a prospective buyer that our property might still be for sale, even though it already closed. Get real. Yes, the answer is B. Awesome. A broker distributes trust funds during the closing day. Typically, it's the title company, okay, or the escrow officer. However, if a broker has trust funds, like let's say deposits, or a property management company, and they have deposits or something, they distribute them to the title company or to the appropriate new owner. That's the day to do it. Distribute them at the closing of escrow, because that's when the title company or the escrow officer does it, right? They receive the money from the bank that is loaning the money to the buyer. And if the seller has to bring in some money, they bring it in on closing, that everybody signs and everything is reported to the lender and it's recorded. Now the money is paid. Sometimes it happens the next day, all right, but it happens during closing. So if they all signed late in the afternoon, well, it's going to be too late to distribute funds. And they call it disbursements, where they write checks or do direct deposits. Now we have more automated systems. Individuals can use an app for the title company to deposit their earnest money instead of going personally to deliver a check, or instead of the realtor going to pick it up. They also have couriers, not all of them, but some do. So COVID brought about a lot of improvements. Some already existed, others did not. All right. So I hope I said hello, Maria. I can't remember. And if I haven't, thank you for joining us tonight. All right, number 10. I think everybody got that one right. Yes. So which of the following constitutes the unauthorized practice of law? Okay, we are not to practice law. So which one is considered practicing law of A, B, C, or D? A, advising a seller that our property has a title defect. B, completes a Texas Real Estate Commission promulgated contract. C, informing a buyer that a property purchase entails numerous legal ramifications. Or D, advising a seller to obtain sufficient property insurance. So which one constitutes the unauthorized practice of law? So we do advise our clients, right? However, only on certain things that we have been trained and educated on, not on legal matters. If they need more explanation of the contract, then we can send them to an attorney. No, it is B. We fix. We're not writing, we're completing the blanks. So we complete the blanks in a contract, in promulgated documents. That is legal. We don't rewrite anything. We don't add our own comments under special provisions. Okay, on that section, the seller can say, hey, write that in there. The buyer can say, write this in there. As long as there is not a promulgated document that applies to the statements that are going to be put in special provisions, then we type that in there for our clients. We don't put anything that we want. We ask the client questions, the principal, the seller, the buyer, and then we fill in the blanks. The templates are the promulgated contracts. There are templates already created by the 13-member committee, right? 6 attorneys, 6 brokers, and 1 civilian. So the answer here is A. A is a title, okay? The title shows the history of ownership of a particular property, and they're saying it has a defect. We send that to somebody else. We're not the ones that determine on explaining what the type of defect is. We can say, hey, you know what? It's important. That defect could have an impact. Go talk to an attorney. Okay, that is not what we're here to do, because we're not attorneys. We're not legal experts. That is going to require research. You know, those are encumbrances. Okay, those are clouds on title. It's a defect. It could be a name. It could be a wrong date or something that was done incorrectly. That's why there's title insurance that is purchased when property is bought, so that in case there's a human error made, a typo error, it can be corrected based on the title insurance that was bought from a title company for that particular property. Okay, y'all get that? So let's see, Lisbeth, you said complete track. No, we complete track document. Okay, so when they say complete, we're only completing the blanks. All right. And if we're missing a particular document, the compliance department will let us know you're missing document so-and-so, add this, have both parties sign. Okay, and we include it. and then they give us the green light or a red light. So compliance keep us in line legally. And that's why we have E&O that we pay for every single transaction. In a company that you do not pay E&O, it's because they probably have a general E&O for all the contracts of that. It could be smaller companies. And if someone says, if you open your own brokerage after you've been practicing for a few years and you say, no, I don't need E&O. Oh boy, you better watch out. Better pay for your own E&O for every single transaction. It's insurance, right? To protect if something goes wrong. Remember, lots of sue happy people out there. Happy dappy dappy. All right, let's do a couple more, right? I like the number 7. So we're going to go to 7, right? I'm the 7th child. That's my lucky number. All right, number 11. Oh, 7-Eleven, right? That's how I remember how many acres, how many square feet in a yard, 7-Eleven. I did a little short on that. It's at the end of the short. How many square feet in an acre? 43,560. The 2 numbers total 7. The last 3 numbers total 11. Which number goes on the outside? The bigger number. 43, the 4. 560, the 6. That's how I remember that there's 43,560 square feet in 1 acre. I'm talking about how to calculate acreage in land or a lot. So I did a short on that. All right, number 11. Which of the following constitutes practicing law without a license? Okay, so which one would cause us to be penalized by practicing law without a license, or even practicing law with a license? Okay, but in this case, it's constitute practicing law without a license. A license, and that's a legal license, right? Without being an attorney. A licensee completing lease blanks in a lease that was written by an attorney. B, an agent completing a promulgated contract. C, a licensee completing the blanks in a contract prepared by a principal. Or D, a licensee altering a lease clause at the direction of a principal. So which one of the following constitutes practicing law without a license? All right. D. That is correct. A licensee altering a lease clause at the direction of a principal. We do not alter clauses. We do not change clauses. We fill in the blanks. Fill in the blanks. Fill in the blanks. That's what we do. Under whose instructions? The principal. Not under our own. We work for the principal. We don't work for the brokerage. We work for the principal. Unless you're an employee of the brokerage, right? You could be an employee. We are contractors. So we work for the client because the seller in most transactions, the seller is the one that pays the listing realtor, and the listing realtor shares part of their commission with the buying brokerage. Actually, it's the listing brokerage to the buying brokerage. Okay. So the seller pays, let's say 6% or 10%, and that realtor decides on how they want to split that with the agreement of the seller. And they'll split it if it's 10%, 5, or 7 and 3, to encourage the realtors to the buying agents to bring a buyer, right? Our fiduciary is to represent a buyer, no matter what the commission is. However, it is very enticing to many. If the commission is higher, they're going to go show that house versus one that has a lower commission, even though that may not be the perfect house for their client. All right, so 11D. Let's see if there's anything else here. So altering of a lease clause requires the creation of a legal contract clause, which requires an attorney. All right, number 12. Which of the following best describes trust funds? What are trust funds? When are they used? How are they used? A tenant security deposit. B, a rent check paid by to a landlord. C, an unearned fee charged by a tenant, charged to a tenant. Or D, any money held on behalf of another. So when we're representing clients, we're considered realtors. And what is kind of the definition? We're getting paid by representing somebody else. We're doing real estate activities for another in exchange for compensation, right? It has that word, for another. So in this case, hey, Kamanani, how you doing? Happy New Year. Welcome back. Welcome back, Carter. Welcome back, Kamanani. Yeah, the answer is D. Any money held on behalf of another is considered trust funds, and it's put into a trust fund. It could be, pet deposit, the last month's rent, regular deposit, anything that's charged monthly, that'll go to the landlord, right? Or for any other things that has to be paid. But money held, so it's held during the lease term. And once the lease term ends, they determine what to do with that money. And that money is held in a trust fund. And it is a trust account. Okay, a trust bank account. Oh, wow. Kamanani passed the state. Glad to join in. You passed your state exam. Woohoo! Congratulations. Oh my gosh, when did you pass it? Look at all that celebration. That's an awesome way to end the session with someone, Kamanani, passing the state exam. Fantastic. Oh, that's right. You were taking it on the 28th. No, wait a minute. 12, 28. Okay, I'm confused here. Oh, January 2nd, January 28th, 2023. Was that it? January 28th? No, can't be. We're not the 28th yet. Or January 2nd. So you passed the state exam. So now you have the national and you're taking it on the 28th. Is that what I understand? So you get much. Yes. Thank you much. Last time. Okay. All right. I'm a little nerd. What is the acronym BEW? I know BTY by the BTW. What is BEY? New Year's Eve retake. We took it on New Year's Eve. All right. So that's awesome. Yeah, I think you posted on YouTube, right, that you're taking it on 28th and somebody wished you luck and so did I. Fantastic. No, I don't know them either. What are you all talking about? You don't know who either. Who is BEW? Bo? I don't know. Oh, typing fast. Yes, I tested then. Okay. So I don't know who, what you're talking about, Bo. Coming up. Yes, on the 28th. Yeah. Awesome. Any questions before we go on? And on Saturday, we went into other topics. I had students ask other questions, and I said, I'm going to do a session to allow you all to ask questions about your concerns about becoming a realtor, what it's really like, what to expect, how to choose, what activities, those types of things. I did a little bit about that. I was talking about the acronyms. Oh, you don't know what that is. You don't know it either. Okay. Oh, that was an oops. Oh yeah, I do lots of those. Oops. Lots of laugh. We all make mistakes, right? Any questions that you may have in general, okay, that I may be able to answer for you, as to what it's really like in the real world of real estate. So congratulations, Kamanani. That was awesome. Let us know what you studied, how often you studied, and was it a prep book? Did you watch YouTube videos, different YouTube tutors? Did you go to a prep course? What did you do? And did you study a lot of vocabulary? All right. So how is the onboarding with ESPs? Does it take long? No, it takes as long as you want it to take. All right. So the onboarding, as soon as you sign up with the application with EXP, the independent contract, and you're accepted, the onboarding starts. What takes some time is the courses that you're taking, the mentorship courses, learning how to, there's a track star and beginning, fast start series. It teaches you about gold. So you've got to take classes with the brokerage, and then you've got to take training orientation with their MLS and pay the MLS dues, pay the brokerage dues once a month. There's a lot of money that comes into effect at the beginning. And so if you're going to be doing this full time and you're single, you have time on your hands. It's paying attention to all the emails that start coming to you, because we are a virtual company, and you start attending the online, our EXP World orientation, the local board orientation that allows you to access the MLS. But the EXP onboarding and orientation can happen pretty quickly. Within a couple of days, you become a realtor and your license is transferred. Actually, it can happen within 24 hours. What happens after that is your orientation, the courses, and what they expect you to take in order to be able to do the business. And in the meantime, you start going and viewing vacant homes, okay? But of course, you have to have already the MLS and the phone app on your phone in order to open the digital lock boxes. Others will have combination lock boxes. So a lot of this is done on apps so that you don't have to get on your computer to the MLS. You can do it on an app. Of course, we have more material accessible online with the MLS board. However, you start going out to view properties, get your business cards as quick as possible. If you don't have them, make some quickie ones. All right. And, buy business cards at Office Depot and then create one. There's a lot on Canva or other software that you can make. And even you can, from the software that you buy from the templates of the business card. However, most brokerages are going to provide you with some business cards. And while you order those, take your classes, start telling everybody, post it on your social media, on Facebook, Instagram, TikTok, Twitter, wherever you have LinkedIn, social media. Start telling the world that you are now a licensed realtor and available to help them with their real estate needs. So the quickest thing to say is, who do you know that I may talk to this week that is interested in buying or selling or investing in real estate? And you start letting everybody know. Don't be a secret agent. And then start viewing real estate properties while you're taking your courses. And when I'm saying courses, I mean your training courses with that particular, or classes with that particular brokerage. Each has their own type of training, okay, on dealing with buyers, sellers, scripts and, marketing, open houses, door knocking, cold calling, you're going to have a lot of information that's going to overwhelm you. So you've got to take a little bit at a time. So let's see here. So I hope that answered your question, Maria. And if you wish to talk to me about it, hey, I have a link in the description, and make a 30-minute appointment with me, Calendly. And there's also a link on there that says learn about EXP with our Dream Team Zone, Lillie Handy Dominguez. And there's a video on there that Kyle Handy, my sponsor, does. And then you can schedule an appointment with the talk, answer questions. So how often do you use Hub? The Hub, you mean the EXP World Hub? Not sure what hub you're referring to, Kamanani. See trust contracts. Okay, I'm a little lost with some of these questions now, or comments. It says, how do you know the status of the title if you can't advise that the title has a defect? Okay. The title companies are going to have titles on prior properties. All right. If a client says, hey, I have a prior, and it's actually a title insurance, the warranty deed is what lets you know that a person has title ownership to a property. The title abstract is when there's a contract at the title company, and then they provide title insurance, and that title insurance discusses everything that's on that property and protects anyone in case there's any errors. We don't explain the defects. Okay, that's for the title company to do that. The title company has their own attorneys. And the title defects, okay, you can go to a title, an individual can go to a title company and says, hey, could you print the title history of this particular property so that I can see if there's any liens? So you can go to the courthouse and look at all the recorded documents and see if there's any liens on that property. So anything that's attached to that property will be recorded at the county clerk house, and those are title defects. Okay, however, if they have a title commitment that was given to them, okay, that's not for us to explain that. They need to go to an attorney. We don't determine that it has a defect. They might say, hey, our property has a defect. Okay, go talk to an attorney. They'll explain what the title defect is, not our place. So we do not advise them of a title defect. We advise them to go talk to an attorney, because that is a legal document. And that is not recorded. It's the warranty deed and the deed of trust that's recorded. However, anything that is recorded on that property is part of the title, part of the ownership that creates an encumbrance, that creates a lien, an attachment. Excuse me. Okay. So did you get that, Delta? So yeah, away from explaining the title. And actually, the time where we see the title, it's a title abstract, that the research that the title company did on the history of ownership, the chain of ownership for that particular property. Then they provide us as realtors with that and provide it to their client, and then let us know these things have to be taken care of by the client. Some could, prevent the property from being sold until they get fixed. Okay, so it says, Kamanani studied champion class in person. Great. YouTube, all your past videos, you have vocabulary. Yes. Texas State HUD questions, 2019 ML or ML. Michigan? No, MI. So another place that you want to go and study questions is on the Texas Real Estate Commission frequently asked questions, FAQ. They have a lot of questions on there. Those are free questions. Go to Texas Real Estate Commission website, and there are a lot of questions there on all the different topics. Magic Wizard 2019, 2020, 2022, 2023, example helpful and national. Awesome. Awesome. See, she studied a lot of resources, and, took a prep class, or let's see, you studied you took a prep class with Champion. Okay, there are different classes. So if you took your courses from Champion, more than likely you'll take them there. And okay, Delta, you got it. Very good. And what's the next one? Good questions. Keep them coming. Do we have special tools to do CMA? Oh, yeah. Yeah. We have the okay, that you become a member with. They'll teach you classes on how to do a CMA. And then there's a lot of online on YouTube that you can, go and learn the particular CMA on your particular state or your particular city, okay, or your county, whatever MLS you belong to. The other source that we have, it's called RPR, Realtor Property Resources. That is national. That is provided to us by NAR as part of our dues that we pay every year. You can search any property in the US that is owned by an individual or an entity or individuals. That has a very extensive CMA, and it's much quicker to do, and it's awesome. So I do that one. I do the comparable market analysis with my local MLS. And then, I also look at the county records, assessed value. And then there's another program called CRS. It's a county recording system, courts recording system. So that shows the records directly from the county of that particular property. Yes, we have resources. And you can also do it on the MLS app on your phone. It'll do a quickie comparable, at least ours does here at San Antonio Board of Realtors. And I love that because that's a quickie. If I'm out there with a client, I'm like, okay, let's do a quickie comparable with a buyer. I said, look, this is what these properties have been closing for within the last, 3 months or 6 months, depending on how fast the market is changing. So we do have special tools. You get a lot of good tools when you join the MLS in your area and the National Association of Realtors. Thing is to learn and how to use them. You've got to go to an orientation with your own MLS and also an orientation with like EXP or the brokers that you're with. They'll also have some classes on how to do CMAs. Any other questions? Excellent questions. Keep them coming. If not, we'll call it a night. And Kamanani, hey, great big congratulations. All right. And may you definitely pass your national exam that's coming up on the 20th, right? That's the national? No, the state exam. You passed the national. That's why you're here, state questions. And many of you can interact with each other and create a little study group online. Do it on Zoom, do it on Google Hangout, do it on Messenger or whatever other apps you have that are free to study together. Or if you live in a local area, study together locally. It helps. It really does. Okay. You're very welcome, LaQuinn and Delta. How much do they cost? Okay, how much does what cost? Be more specific, please. Hey, I did a video about take a shower on Sunday. Because you may not have time for the rest of the week. Oh my God, it got like 1.3 views, 1,300 views because this guy says, say, what? What did I just hear? I was being in a funny mood. Oh, the CMA tools are free. Well, they're free with the dues that we pay to our local MLS and to the yearly National Association of Realtors. Okay. When you become a realtor status, Okay. And the difference between being an agent and a realtor is that as an agent, you're paying for a local MLS, for the Texas Association of Realtors and the National Association of Realtors, and then you become a realtor. Some people say, well, I'm just paying for the title. No, we also get other tools available. We get discounts on certain products that we can buy, okay, to help us with our business. We get a monthly magazine, okay, so that we can stay up with current laws and local activities and or national activities, statuses, and interviewing, top realtors or how they made it. So it's not an additional cost that you pay. It's part of our yearly dues that we pay every January 1st, and of the quarterly dues that we pay for access to our multiple listing service where all the listings are uploaded. And they're a neutral party. Okay, they have nothing to do. They're providing a service to upload all the multiple listings and manage them and keep track of when they are active, or they have an offer, they're an option, or they're pending, or they're removed, things like that, or they expire. So that is not an extra fee. It's already included in the fees that we pay. So be prepared when you get started, okay, to have to pay, $600 or more, because you pay an application fee to your board, an application fee to the brokerage. Most of them charge for it. The quarterly dues for 3 months at a time, and then the yearly due that is prorated. So that's a lot of money getting started. Okay. And then we also get the app on our phone to you that goes along with our MLS online. We also have another app that allows us to access the homes. It's called the Super Key. And then we have another app for when we ask for showing a property, then it's called Showing Time. In our area, it's called Showing Time. So Showing Time, it's a showing service that contacts the seller and makes sure that we can schedule an appointment to view a property. So Showing Time eliminates the step of realtors having to call the listing realtor and us missing an opportunity for an appointment. So now there's this showing service that's available 24 hours a day. And properties typically can be shown from 8 to 7 in the morning, 8 in the morning to 7 p.m. So lock boxes are controlled unless it's a combination lock. If it's a digital lockbox, they're controlled. All right, if no further questions, we'll call it a night. And remember to take breaks when you're studying, okay? It's best to do 20-minute breaks, 25-minute breaks. Take a 20 to 25 minutes study sessions, take a 1 to 3 minute break, 5-minute break, and get started again. Why? Because you remember the beginning and the end of every study session. And that's how you accomplish more and remember more. Oh, you're very welcome, Delta. I enjoy it. Thank you very much, all of you, for attending. And I wish you the best. And we all do say what? I passed, I passed, I passed. Woohoo! Until next time, catch y'all later.